if even one juror hears the comments and it affects the process, then the defendant should have a new trial. And that juror that testified did say, yeah, she thinks it affected her decision. And it shocked me. I was just shocked when the judge of the hearing decided not to set the verdict aside and decided he was not, he did not deserve a new trial based on that. And I said that was wrong from the beginning. And the Supreme Court agreed and said that was just crazy. That should not have happened. And based on that, based on the clerk of court's improper comments, he should get a new trial. What's good, people? I'm attorney John Mobley. I have prosecuted and litigated complex civil and criminal cases for over 30 years, and I'm still actively litigating these cases today. My experience was forged in the legal trenches, going toe-to-toe with some of the best lawyers in the country, and I'm still actively litigating these cases. On this podcast, I'll be giving no-holds-barred, hard-hitting legal analysis on the legal issues that are gripping the nation. But you want to hear more than just legalese or legal mumbo-jumbo. It's important to have the perspective of a non-lawyer. So my assistant Kayla is joining me in the podcast, and she's going to ask me the tough questions for which you want the answers. So please join me on Legal Deep Dives and listen to me call it like I see it. What's good, people? Attorney John Mobley here. Welcome to Legal Deep Dives here in the club room with my assistant Kayla. Kayla, I would ask you how you doing, but like I always say, everyone can look at you and tell you look like $1 million, so you must be doing pretty good.
Same to you.
So, what's going on with you, Kayla?
Not much. Learning a lot of new things, trying to be outside, summer, hot. Just gotta go with it. What about you? You feel like you've been booked and busy. What's been going on with you?
I've actually had quite an interesting couple of weeks. There's a case here in South Carolina that's it's a murder that received a lot of attention in this state and nationally, where an Asian gas station kind of mini mart owner shot and killed a 14-year-old black teenager who he suspected of stealing a bottle of water, and ultimately the kid did not. But he and his son chased the teen over 100 yards, and ultimately what happened is the teen had a gun in his backpack. The teen couldn't get away from them. They kept chasing him. The teen pulled the gun, and the store owner pulled his gun, because he had a weapon, and shot the teen in the back and killed him and was charged with murder. And, although it was a case that got a lot of attention here, it's just, it happened 3 years ago, and I just don't follow the news like that. There's just always a case that's getting attention, and, you read it one day and there's another one the next day. Mm-hmm. And so like a couple of weeks ago, I'm just kind of sitting there smoking a cigar, and a local news station called me and asked me to do some commentary for the case, and I said sure, knowing nothing about the case. So anyway, so I did my research and I did some commentary, and apparently the coverage for my commentary got a lot of attention. To the point where I got a lot of attention on social media talking about it, and another news station that saw my commentary and saw my social media, even they asked me to reach out to them and meet with them to discuss the case. And all the people are just saying, oh my God, your insight, your perspective on that case is amazing. I'm getting politicians, other lawyers, lay people all just saying, oh my, your insight was just, terrific. And you helped us understand so much. And I guess I just found it interesting because as much as, I try to put out, information that's informative and educational, and of course, slightly entertaining, I don't see myself as being any different than anybody else. So I was just kind of shocked and surprised that with all the lawyers that are putting out content and discussing this case, that, my information was getting so much attention. So, and that's the case of the State versus Rick Chow. That was the defendant. He was accused of, what he did, he shot and killed a 14-year-old teenager, Cyrus Belton, and was charged with murder. And, the end result of that case was he was found not guilty, which caused an even bigger backlash in the community. I mean, everybody in that case, and I tell you what, I guess I'm glad I was not actually involved in the case, because everyone in that case, all the lawyers are just getting flack, and they're getting, negative comments. The prosecutor is getting grief from the community leaders and people that thought he did a horrible job in the prosecution. One of the defense attorneys was black, and he did an excellent job in the case. And he is getting death threats. His family's getting death threats. People are just, in the community are calling him out, sell out, and it's just crazy how everybody involved in this case is getting so much, negative outcry and backlash from people in the community. And so I'm lucky that I was really just kind of on the sidelines, really just kind of, playing Monday morning quarterback for how everybody was doing with the case. So it's been an interesting couple of weeks for me.
Yeah, I mean, it's been interesting seeing your input on it, and I agree with everybody. It's nice to see different perspectives, and you always call it like you see it. So I'm sure that's one of the reasons it's gotten so far. But speaking of South Carolina murders, let's talk about Alex Murdaugh.
My old colleague, Alex Murdaugh.
Yes. What has been going on with that? What's the latest news? I mean, this has been going on forever. When will it end? What's going on?
I will say this. Anybody who's watching this podcast, you go back and look at my old prior podcast discussing the Alex Murdaugh case. I said over and over on multiple occasions that after he was convicted, this conviction would be reversed. Mm-hmm. I said it over and over. I said this case is going to be around for a long time. And, I like to be right, of course. And really, but what's happened with Alex Murdaugh is, and everybody's seen, his conviction has been reversed based on primarily the inappropriate conduct by the clerk of court. And when I say that, just to refresh everyone's memory, after he was convicted, the defense attorneys were made aware that the clerk of court had allegedly made comments to the jury that were inappropriate.
Yeah, I was going to ask you about that. I was going to ask kind of how that had an effect on it and like what extent did that bring onto the trial of her trying to influence these jurors?
It's just crazy because, I mean, and there's certain cases you just, that I look at the defendant or the person that committed the conduct and I just think, how could you have not known this was just stupid? But, the clerk of court, she apparently had a book deal in the works while she was, she wasn't presiding, but she was the clerk of court while this trial was going on. So she's in charge of all the administrative issues, dealing with the jury, things like that. And she got a book deal. Mm-hmm. And, of course, she wanted to make money from that, which really I think it's inappropriate for her while she's in office to cut a book deal about a case that she is somehow has some involvement in. I think she should have just waited. But anyway, she didn't wait. And after the verdict, some jurors said that she made comments to them regarding Murdaugh, regarding the defense, and that, potentially affected the outcome. Now, that's a problem because, when the jury's deliberating or jury's in panel, there should not be any kind of external communication to them about the case. And when I say that, it's okay for the clerk of court to have some contact with them. The juror might say, okay, well, hey, I need a cigarette break, or hey, I've got a kidney issue. I need to go to the bathroom.
Yeah.
Where's the bathroom? Or hey, if we're going to be late, can I make arrangements, childcare arrangements? I mean, they're just little administrative things like that the jurors may have questions about.
Normal communication.
Yes,
yeah.
And of course, the clerk has got to make herself available to answer those questions because they're not really pertaining to the case. But the clerk of court in this case made comments based on jurors that testified that, she was saying things like, watch him closely, meaning the defendant Murdaugh, don't let him fool you. I mean, it's insane that she would make statements like that. And when it first came out, of course, she denied making the statements, but there was a hearing. And what I recall about the hearing on that, there's a post-trial hearing after he was convicted. What I recall is, she came to the hearing, and she came to the hearing with two lawyers. And I'm like, the clerk of court, I'm like, why are you coming with not just one, but two lawyers? And of course, she testified that she never made any of those statements. She never even talked to the jury, which was just a lie. I mean, to say she never even talked to the jury was just a lie. She had no credibility. And ultimately, the law is if there's an improper communication that might have affected the outcome, then the defendant should receive a new trial.
Right.
And that juror testified that those comments, and I want to be clear, some of the jurors testified they didn't hear anything, which is fine. But if even one juror hears the comments and it affects the process, then the defendant should have a new trial. And that juror that testified did say, yeah, she thinks it affected her decision. And it shocked me. I was just shocked when the judge of the hearing decided not to set the verdict aside and decided he was not, he did not deserve a new trial based on that. I said that was wrong from the beginning, and the Supreme Court agreed and said that was just crazy. That should not have happened. And based on that, based on the clerk of court's improper comments, he should get a new trial. I also want to add that I thought the admission of all the financial crimes, that evidence, I didn't think that was appropriate or relevant. I always said that. The Supreme Court addressed that. They didn't reverse it on those grounds because they felt like the clerk of court's conduct was bad enough that they didn't need to look any further. But they did caution the trial judge for the next trial that they let the prosecutors get in way too much of that evidence, and then they let it get too far. So ultimately, at this point, Alex Murdaugh, it will be having a new murder trial. He gets a reset, and so he's had a very, very good couple of weeks.
Yeah. Do you think they'll continue to pursue the financial charges, or do you think that maybe they'll stop? And honestly, which way do you think would be better? Which way do you think would either help or hurt the case the most?
I mean, and I want to make sure I clarify. He was prosecuted for the financial crimes separately. Okay. And pled guilty to those crimes. Okay. The financial crimes were used as evidence in the murder for his motive. And I've said it. I will sound like a broken record, but that's fine. I said it 100 times. I believe that the financial crimes had no connection to the murder. And for everyone that didn't follow the trial closely, the state's position was, he had stolen all this money from his clients and his firm. The investigation was coming, and he was trying to somehow postpone the investigation and make himself look more sympathetic by, murdering his wife and son. Mm-hmm. And I just said that's just honestly the dumbest, stupidest, making no sense theory that I've ever heard. And, for a lot of different reasons. I mean, number one, Murdaugh had been getting away with this stuff for years.
Yeah,
Okay?
I saw it started in 2019 with the boat crash.
Okay, I mean, just financial crime, and they're money crimes. That they were not violent crimes; they were money crimes, stealing, and and the thing is, with financial crimes, I mean, that paper trail doesn't go away.
Right.
I mean, him murdering his son and his wife is not going to just make all that red ink and all those numbers just go away. Mm-hmm. It was going to still be there. And whether his wife and son were murdered or not, that train was still coming down the tracks. It might have slowed it down a little bit, but it was still coming. It wasn't going to go away. So when you think about, okay, well, I want to slow it down. I know I'll murder my wife and my son and commit a more serious crime against people I love in order to somehow slow that investigation down. It just doesn't make any sense whatsoever. Mm-hmm. And also when you think about, from his standpoint, when you have financial crimes, I mean, typically, why would he not think he could just buy his way out of them? I mean, he got the connections. I mean, most victims in financial crimes, they want the money back. Because if somebody steals millions of dollars from people and that person gets prosecuted and sent to prison, I mean, they don't get their money back. Mm-hmm. I mean, the judge can order the defendant to pay restitution, but how's somebody who's in prison going to pay you money back?
Yeah.
Okay. And if he doesn't pay you the money back, he doesn't do any more time for it. So most victims, they want their money. He would know that. He would have had the opportunity to say, listen, I'm sorry, let me pay you back. Let me get you this money back. Let me hire some lawyers, get this thing done, sign a confidentiality agreement, don't prosecute, and I'll write you a check. I mean, he could have done that. Why would he not think he could not have gotten away with it? Mm-hmm. I mean, that's my whole point. This whole idea that, instead of thinking he could get away with something he's been getting away with for years, he would commit 2 horrific double homicides. It just doesn't make sense. And in addition to that, I mean, there were no statements he made saying, hey, if there was evidence that he made a statement that, hey, I got to derail this investigation. I got to get attention off myself. I got to seem more sympathetic. I got to do something. If he had made statements like that, I think, okay, yeah, you can try to make the argument. But he didn't. That was just some theory that prosecutors used. And I always said, there's a good reason for them to try to do that.
Yeah. Okay, so steering back to the conviction reversal, when a conviction is reversed on an appeal, who has the advantage, the state or the defendant?
Well, it really kind of depends. The majority of the time, I believe the defendant has the advantage. I've had to do retrials in the past for cases that, I got a verdict and the judge ordered a new trial, or there's a mistrial and got to try the case again, or the case got reversed on appeal. And I would say typically it is more advantageous for the defendant. And I will tell you why. Because in a criminal case, unlike a civil case where you can take depositions of every potential witness, in a criminal case, you might know the names of all the potential witnesses that are going to testify for the state, but you don't always know exactly what they're going to say. So when you're trying any kind of criminal case, there'll be 20, 25 witnesses. It happened to me. I've tried cases where, I show up to trial and it's jury selection, and the state has to the judge requires the state, both sides typically, to provide a list of all the potential witnesses they might call to make sure the jury may not know them. Because, who asked the jury, okay, does anyone know, John Malba? Does anybody know Mike Drew? Does anybody know Kayla Thompson? But, so you kind of have to provide those names to the judge to make sure that the jury's asked those questions. I've tried cases where, I might have known about 5 witnesses and there's like a list of like 25 people. And what that means for the defense lawyer and what it meant for me is, okay, well, I guess I'll figure out what they're going to say when they get on the witness stand. And from there, I got to cross-examine them cold. I got to figure out, I'm hearing what they're saying for the first time. I got to figure out what questions I'm going to ask them and how I'm going to incorporate those questions into my theory of the defense, and having to do that for 15, 20 people, not just lay witnesses, but also experts.
Yeah.
Because witnesses don't have to talk to you. I mean, quite frankly, most of the time, if you go, hey, I represent this guy charged with murder, but you're a witness, will you talk to me? They're going to slam the door in your face. If you call a police crime scene expert and say, hey, I represent this guy charged with murder, you worked on the case, will you talk to me about your findings and some of the things you did on the case? They're going to tell you no. So, but once you've had the trial, you've heard them testify, you can get transcript of the testimony, and you've kind of locked them in. And so that's a big advantage because now you know what they're going to say, and you can reshape and alter your questions to lock them in on facts that actually help, your defense.
Right.
So typically it is a big, big advantage for the defense. Now, I will say the flip side is if the defense, put up a lot of defense witnesses, well, the same thing goes for the state. Well, now they have access to all of your witnesses' information and how they testified and what their opinions were, and they can try to investigate and perhaps find information to help impeach their testimony. Because and that's a disadvantage for the defense because now the defense loses what I've always said is the biggest weapon for the defense, and that is the element of surprise. I always say Pearl Harbor because Pearl Harbor, we were all surprised by the Japanese bombing of Pearl Harbor because again, when the state doesn't know what your witnesses are going to say, that puts them on the defensive. They kind of have to react. They're on their heels, and and oftentimes, I'll have 2 or 3 or 4 or 5 witnesses, lay witnesses, saying the exact same thing. And the state can cross-examine them all they want, but I'll stand up in front of the jury in closing argument and say, I challenge the state to say all 5 of these people are lying. What are they going to say? All the people are lying? Of course they're not going to say that.
No.
So, but again, generally it's the defense's advantage, but I think in this case it's going to cut both ways. So here's the deal. Sometimes when I'm doing these things, I tend to get a tad loquacious, and which means I talk too much. Shocking. So, but what that means is I think I probably need to kind of take a break right now, make this a 2-parter. So we're going to end where we are right now and pick up in part 2 on the next podcast. So in the meantime, I appreciate your comments. Do me a favor, post your comments, post your questions, call it like you see it. That's it.